Bună ziua și bine ați revenit la ora arbitrajului. Încă o dată, astăzi vom fi nevoiți de profilul invitatului nostru să discutăm în limba engleză, fiind vorba despre un străin, un italian, care vorbește limba arbitrajului internațional, limba engleză și în general și cu ocazia acestei emisiuni. So, as I was saying, as it has happened already several times, the language of our today's session is English, and I have the pleasure to introduce our guest today. The name is very familiar for everybody involved in construction disputes, construction projects, especially infrastructure construction projects here in Romania. Mr. Giovanni Di Folco, who is the manager running Techno Engineering Associates Group. Welcome, Mr. Di Folco.
Thank you very much for inviting me, Dr. Vasile. It's really a pleasure.
I'm sure that we are going to have a very interesting debate on your favorite topic, which are international arbitration and alternative dispute resolution mechanisms associated to arbitration, and all of them in connection with construction disputes, which is your specialization. I was saying earlier that everybody involved in certain types of projects, construction projects, knows perfectly you and your company. I would choose today an unusual approach for a moderator. I would kindly ask you to introduce yourself and your company rather than me going through the impressive CV, both your personal and your company's one.
Thank you, Dr. Vasile. I'm a civil engineer by trade with 35 years experience in the field of transportation engineering. I specialized early on in design and construction and project management, and later on in my life I specialized in contract management, dispute avoidance, dispute resolution, with a special focus on international adjudication and arbitration. My engineering background allowed me to pursue certain expertises in delay analysis and quantum engineering, as well as technical forensic analysis for concrete structures and asphalt works. The company I co-own together with my partner was a well-known professional in the Romanian industry. She is engineer Eugenia Dunca. It's a medium-sized techno-legal consulting engineering firm with 4 international offices, main office in Romania. 150 people, and 20 of them are construction lawyers. So the rest are engineers specializing in planning, contract, quantity surveying, quantum, and there is a number of experts in delay analysis and quantum engineering that they give evidence in court regularly. The company works in about 14 different countries. We cover the Middle East, Europe and the Balkans, North Africa, Canada, North America and Latin America. And this is pretty much about what we do.
Okay, isn't it a little bit unusual for such a company to have its main headquarters in Romania, even if you are a truly international company? What's the explanation for an Italian setting up the main headquarters of an international company in Romania?
Well, the choice of Romania was not one that just came by pure chance. My partner and I, we looked at various venues, and we did obviously our homework, and we did research of South Europe, East Europe, on countries that would have offered best place to start a consulting engineering firm specialized like ours. And Romania came up top together with Poland, and we chose Romania. The reason was a very large pool of graduate engineers and lawyers, the use of the English language in contracts, the use of FIDIC conditions of contract, the use of dispute boards, the use of international arbitration, ICC arbitration, And then at the time that we established 15 years ago, the construction market in Romania was very interesting. Most probably one of the most interesting in Europe at that time. All these together gave us the confidence that we could invest in Romania as a first starting point for our consulting firm.
Mm. And about the profile of Techno Engineering and Associates, actually what you do is to provide integrated services to construction companies or employers, beneficiaries of construction in construction contracts. Is this sort of mixed profile, technical plus legal, unique? Is something that you felt necessary to implement, or it is a concept that you can find in other jurisdictions also?
By choice, my partner and I decided that we should have dedicated our services to only one side of the industry, of the construction industry, and that was the one of construction company. Only in that direction, and not take on work for employers or sureties, bankers, or...
You never accept mandates for
employers. We never accepted a mandate. Yeah. We felt that we come both from a construction background, and it would have been better to do what we know how to do best. The techno-legal was something that we had in mind from the very beginning. We are in the top tier internationally as amongst the 10 largest consulting engineering firms that they do this type of services, but there is only 2 amongst that 10 that they are truly techno-legal. We felt that engineering without the respect and the understanding of the law cannot work, especially in an environment where we provide integrated contract management and claims resolution assistance. There has to be a mix between specialized engineers and specialized lawyers, especially construction lawyers. So it was from the very beginning our concept, and we developed over the years, and it has worked out very well. And I'm proud to say that we are most probably the true techno-legal consulting engineering firm that operates internationally. And
moving a little bit towards arbitration, which is the essence of all our debates here at the Arbitration Hour. For such an impressive portfolio of projects and clients such as yours, how many arbitration proceedings have you been involved in, let's say, in the last 10 years or 15 years, if you have a counter for all these projects?
Well, in the past 15 years, we had a mix of disputations, procedures. We have been involved in about just over 100 international dispute resolutions using the dispute boards mechanism. Yeah. About 20 domestic court cases, and just over 30 international arbitration using the International Chamber of Commerce in Paris, rules and the court.
So I would say that this is the type of result for an average to big law firm specialized in dispute resolution for the period that you have described. More than impressive.
Thank you. If I have to look backwards, I cannot understand how we managed to do all this.
But you did. Now, another, let's say, technical question. As you have mentioned a little bit earlier, you have been involved both in international arbitration proceedings, in dispute resolution cases of construction contracts before Romanian courts, and probably you have also been involved in local arbitration cases, international or domestic, it doesn't matter. Is there, from your perspective, a difference? How do you see these 3 alternative ways providing dispute resolution solution for the needs of the parties involved in this type of contracts?
Well, I would look at a starting point, the dispute resolution and dispute avoidance using dispute boards, or DAB as they're normally known through the FIDIC conditions of contract. We find from an engineering point of view that dispute boards are very effective worldwide. And I am a member of the Dispute Resolution Board Foundation and of the Dispute Board Federation. And we maintain, obviously, an international registers of dispute boards worldwide. And we find that they are very effective in dispute avoidance and in reducing the number of disputes that they do go to arbitration or to court. Mm-hmm. And if they do go to arbitration or the court, the decisions given by these dispute boards are taken into high considerations by arbiter tribunal and court judges. And most of the cases, the results of an arbitration or a court proceeding is pretty much like the decision given by dispute boards. I have mixed feelings about court and arbitration. I find that arbitration has developed, especially over the past 15 years, into something that is dynamic, modern. It is well arranged by the International Chamber of Commerce in Paris. The service that provide it's outstanding. Is the only chamber that provides a quality assurance of the awards. Courts in Romania they've been amazingly good, I must say. I come from a culture of courts in Italy and other countries, which they are all overwhelmed with the number of cases, and the period to arrive to a final resolution is extremely long. I have found surprisingly that Romania is very dynamic. The courts work very well, especially commercial courts. They have a very experienced judges, especially at Court of Appeal and Court of Cassation. And they handle construction cases which are normally very complex reasonably well. There are obviously some downsides to this. The number of experts that they are on the list of Ministry of Justice in Romania, they do not have the type of expertise that the international experts they have, especially in forensic delay analysis and quantum. So overall, I find all three methods of dispute resolutions valid, with arbitration being the most effective one, although it may sometimes turn into quite a long procedure and has a considerable cost compared to the dispute resolution using dispute boards, which is a fraction of that.
Mm-hmm. So I'm trying to reach some conclusions. If you are the one to choose between dispute resolution before state courts and arbitration, it is always going to be arbitration for construction contracts. Is it correct?
Certainly that.
Okay.
I would always advise to use arbitration.
I'm glad to hear, because this is also my view, without any question mark. And irrespective of the fact that indeed Romanian courts do function properly, but not to the extent that arbitration can offer in terms of advantages for the parties. And the second question is, you have correctly described how important dispute adjudication boards and adjudication in general is for construction industry abroad, starting from UK and almost everywhere else. Do you agree with me that there is a huge difference, or at least an important difference, between the outcome of adjudication and the cases when adjudication really represents the last resort, the last stop for the parties in UK and generally in the Western European countries, as opposed to Romania?
Well, indeed, the major difference between the UK adjudication and adjudication generally under FIDIC conditions of contract is that the UK one is a statutory adjudication, so the decisions are enforceable, immediately enforceable by the courts. And if you're looking at the statistics over the past 15 years, Basically, arbitration and court in UK is reduced by half because
of the efficiency
of
adjudication.
the efficiency of adjudication in UK. It's a very effective way of dispute resolutions, and a contractor can get his money straight away because the decision is enforceable immediately. Unfortunately, dispute resolution through FIDIC conditions of contract internationally as an impediment to the fact that the decisions are not res judicata. So for enforcement they need to go through arbitration or the court. Although I've been involved with a colleague of mine from UK, his name is Mark Tigerman, in enforcing some of the first DB decisions which had received the notice of dissatisfaction. Therefore, they were just binding but not finally binding. And we created kind of a precedent, international jurisprudence back in 2010, and then many others followed. It is, I believe, something that needs to be resolved at the EU level or at banking institution levels. To push countries like Romania and many other countries that use dispute boards and use international funds to pass legislation that makes them basically immediately binding, so that a dispute between parties can be resolved, especially regarding payment for work done. Without going through years and years of arbitration or litigation. For instance, if a DB decision could be enforceable and is related to payments for work done, that will resolve a cash flow on a construction contract and will make the project successful. Until that is done, this is one of the downsides of using dispute boards and adjudication, unfortunately.
I'm trying to reach to the real cause or the cause of inefficiency as a final outcome for the adjudication here in Romania. And I dare to say that it is a matter of mentality of the parties involved in construction contracts. Not only state companies, I have seen it also for private companies. First of all, they look at the adjudication not like a potential response for the problem as a final answer. This is it. I owe you that much, or the amount is that, or I don't owe you anything, but like an intermediary step. And it is always the question that occurs is, okay, it may be right, it may be close to the truth, but then let's see what the arbitrators or what the court has to say. Or it is the exactly opposite in UK and in other jurisdictions, because the parties, if they feel that the solution provided by the adjudicator represents the reality or something close to reality, they are not interested to push forward the dispute. In my view, this is the essence. And it is a matter of mentality of Romanian parties. Do you agree with me, or is it?
I agree to the extent that it's not only a mentality of Romania. I think it's just a commercial mentality worldwide. No party wishes to pay another party unless it's forced to do that. It is also a mentality to understand that if you are in a cooperative environment and you believe in partnering and you bring a construction company to build something, it is fair to pay them for what they have built, no more, no less. So I don't see why over the years that they see a dispute board as just as a forced step, as a cost amongst many others for the project. And they don't see that as a dispute avoidance mechanism that will save money in the long run to the parties and will get projects done. So indeed, it's a question of mentality. It's a wrong mentality worldwide in case of construction disputes. There is not a will from the employers especially to find an amicable solution. They want to be always right, and this is an issue that will always create disputes.
Yeah. sticking around the same topic, Romania has recently enacted, I refer to the government decision 1 per 2018, the new contractual conditions for European funds contracts, construction contracts, infrastructure contracts, and how should I say, there are 2 or 3 very important ideas. First of all, adjudication has been completely cancelled in this new set of rules. On one hand, on the other hand, the FIDIC model is, and on the other hand, it is not in force. I have heard a nice metaphor, the FIDIC sui generis or the FIDIC Romanian approach. So it is a FIDIC, but it is not a FIDIC, an adjustment to the Romanian reality. And the third, I would say, important formula in there is that the jurisdiction will be with the Romanian Arbitration Court, International Arbitration Court attached to the Romanian Chamber of Commerce, which means international local arbitration and not ICC, as it has been many times in the past. What's your view on all these 3 ideas? And if you believe that there are others equally important, please feel free to touch them.
I have followed this quasi-saga over the years.
Yeah.
I was very proud to operate in the Romanian market because it was the only country in the world that had adopted the FIDIC conditions of contract as their own national conditions of contract. So it was a bold and courageous step towards the proper contract management and project management, because at the end of the day, the conditions of contract of FIDIC are project management tools, and they are tested internationally. They are written by engineers for engineers, and they are made for international construction.
Theoretically, you don't need to adjust them in any way to make them suitable.
You don't. If you believe in fair approach to construction, you just leave the general conditions of contract as they are, because the allocation of risk is well balanced between the parties. The parties that are responsible for certain risk are best placed to be in their position, because they've been written these conditions of contract by specialists in construction practitioners. What is amazing is that if you look at the new conditions of contract, they're not that much different from the FIDIC condition of contract. However, the downside is that they have removed dispute boards, which is the most important part of a FIDIC contract, because dispute boards are there for dispute avoidance. They reduce disputes, they give opinion, which they are followed, and they really reduce the number of disputes that they go to arbitration. Now, without that method of dispute resolution, matters will have to go to arbitrations during construction, and the number of arbitration will be increased, cost to the parties will be increased, and that is not in the spirit of collaboration between contractors and employers. So all in all, I cannot say that the new conditions of contract are unbalanced or are bad. They are bespoke conditions of contract. They can work. They're quite balanced, but they missed the point that dispute avoidance should have been maintained by the use of dispute boards.
Perhaps maintaining adjudication and adjust the standard adjudication model offered by FIDIC to Romanian realities would have been a more suitable formula also. Because in my view, I'm not aware, and I haven't participated in any way to the discussions and the long debates that led to this formula. But in my view, it is obvious that the Romanian state, who enacted the regulation, believed that the reality and the experience, we have more than 15 years experience with FIDIC contracts, pushed them to adjust slightly in some parts. And as you say, in broad lines, in essence, they remain a FIDIC contract. But give up, abandon completely adjudication, probably because the feedback that they got from the contracts, from the case law, the practice is that adjudication was not efficient, or it was not the solution, the formula, as efficient in other jurisdictions. And probably this is how they reach this conclusion. I cannot provide another interpretation to the formula that we have now as a law for the future projects ongoing.
I think that there was an issue of, obviously, of royalty. I mean, for using FIDIC conditions of contract, the International Federation of Consulting Engineers requires certain agreements with each country that uses them, and they have to be paid some royalties. I don't think that that is an exceptional cost in a construction budget or a country as large as Romania, or even a smaller country. So I cannot see that a matter of cost. So by doing what they have done, I don't think they have saved any money to the government and to the taxpayers. Moving to the fact that there is a perception that adjudication did not work. Well, out of the most probably 150 adjudication in this country, we did 100, and I acted as counsel on all of them. And the various public authorities here, the various employees, they never won one. They lost all of them because obviously they were in the wrong. Now they couldn't face that. But they're going to be the same thing in domestic arbitration, unless someone is ill-advised that think because it's local, they may have most probably a keen eye towards the government. I don't believe that.
No.
Arbitration is independent, and especially this is a new chamber that has been revamped in Romania, which I'm very pleased to see all the changes that have been made, and congratulations, I believe that you're one of the members of the committee. Yeah. It's definitely going to give a better perception that there was in the past. I did very little domestic arbitration in the past, simply by choice. I didn't want to get involved with the domestic arbitration because it did not have a good reputation at the time. Now I see that they have done some major steps in bringing new arbitration rules, which are very much in line with the ICC rules and the international framework. So I believe that that will give a better basis for disputation in arbitration. And I've seen that there is a major overhaul about who the arbitrators are going to be, and to be more selective and bring to the table a pool of young, modern arbitrators, highly qualified, such as yourself, which I think that it will be successful. And together with the initiatives like Romanian Society of Construction Law and the work of FIDIC that still does through a dear friend of mine, Giovanni Di Folco, which is impressive. I think that local arbitration will earn over time the respect that it deserves. But there is still the issue that some or most of the disputes that could have been resolved by a dispute board now will go to arbitration.
Yeah, and indeed this is not at all a perfect solution, because I can imagine a long-term contract for a highway, 5-6 years plus extension of times. It can lead to 2 or 3 parallel arbitration proceedings during the unfolding the execution of the contract, and it is very difficult to continue to perform the contract while being involved in 2 or 3 ongoing cases, and this is going to happen, unfortunately.
This is the unfortunate downside.
Yeah.
Because you know that spirit of cooperation that there should be between engineer supervising the work, the contractor, and the employer, and its representatives is going to be lost into the legal matters that will obviously arise during disputation. It's an unfortunate move that the Romanian government has made. Time will tell. There might be a possibility that they will go back and will rethink the positions about dispute adjudication.
Yeah, if we look back, their view on jurisdiction, contractual formulas has changed slightly, but it has changed in the last 7-10 years. So none of the solutions that they have chosen at a certain point remained unchanged in the future. And probably the feedback will confirm or not the accuracy of one of these formulas.
Well, time will tell, because I mean, new contracts which will be tendered from now on will be with a different contract than FIDIC. But there are a number of contracts still under FIDIC that will go on for another 5-6 years.
Yeah.
So by that time, whether it will completely disappear, the use of FIDIC, or somehow there will be a change of heart at government level, and they will look most probably at using the new FIDIC conditions of contract, the second edition of 2017, which they've been published last year, and they are really excellent conditions of contract.
This was, you have anticipated my next question. Talking about the news and the new guys in town, we cannot avoid discussing a little bit, 5 minutes, about the new 2017 edition of FIDIC contracts. For those people specialized in construction and construction law or not, can you synthesize a little bit what's new? I think this is the question for everybody.
Incidentally, I'm just coming back from Georgia, from Tbilisi, where there was the 4th regional conference of FIDIC and the Association of Consulting Engineering of Georgia. I have been always a fair critique of FIDIC over the years, and starting from the 1990-87, the 4th edition of the Red Book, going to the 1999 first edition, I've always found that there were some loose ends in these conditions of contract. What I have surprisingly found by reviewing the second edition and that was published in 2017 is that they managed in a very elegant way to close those loose ends. Now there is a more prescriptive contract for each of the party. The balance of risks has been improved even more than what was done in the 1999 first edition of FIDIC. I see them much more as a project management tool than the conditions of contract. I really believe, and I'm excited about using them, because I find to be them really well prepared. I'm excited about these new conditions of contract, and I think professionals that they have respect for their profession will look at them with a keen eye, because it brings back the engineer neutrality. So the engineer is still an agent, but he has to act neutral between the parties when he deals with agreement and determinations, which goes back pretty much to the 4th edition of FIDIC, where the engineer was an independent. I don't think FIDIC believed that the use of a word neutral means independent. It just meant that being a professional engineer who neutrally at that point in time provides a dispute avoidance in order to reach an agreement, and there is a prescriptive methodologies how to do that, and then he issue a determination which is far more prescriptive, is more structured, and I believe that the parties will be ill-advised to manipulate these new conditions of contract through the particular conditions, because it will become almost mission impossible, because the contract now has become almost double in size. But was required, was needed, because there were too many loose ends, as I said, they had to be closed, and they managed to do that. A lot of people worked to them. It went through the normal peers review and friendly reviews and committee reviews, and I believe that it's a way to go in construction from now on, using those conditions of contract issued in 2017 by FIDIC.
So I understand that in a very pragmatic and oriented towards result, FIDIC has managed to clarify almost all, hopefully, the famous controversies and debates on some of the contractual formulas and problems that were originated by the unclear and the gaps that the clauses had. When you discussed prior to starting today, you mentioned the clear clarification of that famous situation where the DIB is not in place and the problems that occur because the contract was not signed. And you told me that it's crystal clear, there can be no dispute about it under the new formula. Can you please elaborate a little bit?
Indeed. I mean, FIDIC felt that rightly, I believe, that in order for the DAB to be in place between the parties need to sign a dispute adjudication agreement.
Yeah.
In the past, that was a gap,
yeah.
And there were quite a few ex parte dispute board proceedings that went on, because if a party failed to agree, that is a breach of good faith and a breach of contract.
Many times it refused to sign the agreement because
that should have not deprived the contractor or the employer to pursue the dispute mechanism. However, it had a lot of problems, and a lot of jurisprudence was born on that issue. It's been cleared by FIDIC by saying if the parties do not sign a dispute adjudication agreement with the DAB, there is no DAB in place. Then you move to arbitration.
Crystal clear. Yeah.
It's crystal clear. They have cleared many other issues like the gap, the quasi gap that there was in subclause 20.7, which I personally believe there was never any gap. But now has been made very clear. And the way claims management is now resolved, it's far more prescriptive. There is definitions about what is a claim, the different type of claims, and the way now disputation works. They have really cleared their act. They've done a good job.
Yeah, and I appreciate a lot. I love this legal approach, and I will explain the context. Sometimes it happens that in Romanian laws, you discover surprising legal texts which seem to be redundant, futile, or excessive in explaining an obvious situation. And then I always say that I prefer the legislator providing that useless explanation to make it clear for everybody, rather than leave a question mark for some of the participants to applying the law and create problems in the case. So, and the same here. What's the cost for providing in two other lines? It is like this, it is like that. I think it is preferable, and looking at the case law, looking at, if you remember those hundreds of pages of submissions in one case debating about those gaps, now it is in everybody's interest to clarify some of those situations.
It's indeed so.
Yeah.
A more prescriptive approach brings clarity, and I think it is the right way to go about it.
I have no doubt that the parties are going to be able to discover some other gaps and some other matters of interpretation, but this is another issue.
Well, nothing is impossible for lawyers.
Yeah, I mean, lawyers have to survive. Yeah, we cannot clarify everything and send lawyers home. Let's move to another topic. I think that the most delicate, sensitive, core issues concerning construction disputes are delay analysis methodologies, quantum ascertainment, and concurrency and concurrent delays. They are not all, but they are some of the most sensitive issues. My question is the following, in, again, a very delicate mission request for you. If you can, in 5 minutes, explain a little bit what is your view, and especially I'm very curious, what is your view of how can you solve these problems when you are forced to convince a judge and not an arbitrator about the delay analysis methodologies and to produce evidence to convince the judge in this respect, as an example?
Well, as an expert myself in forensic delay analysis, I've learned over the years that it is only effective if you explain it in such a way that a lawyer understands it.
I think this is a good beginning.
That is the test. If a lawyer understands it, then it is clear and it is going to go ways.
What you say is a golden rule. I always say to my clients when they explain me technical issues, not necessarily in construction contracts, I cannot follow you. If I cannot follow you, it is impossible for a judge to follow your argumentation.
It is true.
Yeah.
It is true. So simplicity is everything.
Yeah.
There is obviously a large amount of due process, that has to be followed in order to prepare a proper forensic delay analysis. The research of the contemporary records and of the contemporaneous programs that have been used. In the past, and still now, is considered a black art. Because has been performed by personnel and professionals who had not been trained properly in forensic delay analysis. If it's done properly by certified engineers and professionals, it is very helpful. And if it's explained in simple terms, it is very effective and credible at dispute adjudication tribunal or arbitration tribunal level or at the judge level. There is, however, a shortage of very good forensic delay analysts worldwide. Even if there are those that they believe to be forensic delay analysts, they are not, in my view. And I see it more and more in arbitrations when I cross-examine so-called expert in delay analysis who unfortunately are not, and they fail miserably on the stand. What is required, I think, is just a clean-up of people's acts, more education towards what is right and what is wrong. And I believe that two organizations have done a brilliant job. The Society of Construction Law, with the latest second edition of the protocol, they brought much clearance regarding forensic delay analysis. And American Association of Cost Engineers has also done greatly with the various publications. And that there is more and more on the market that helps to appreciate what is a forensic profession, a forensic analysis, like any other forensic analysis. It is very important also to look at the common law and civil law approach. I believe that civil law approach has a more pragmatic approach to concurrency, concurrent delay. For me, professionally, true concurrency does not exist. It's a utopia. There can be some concurrent periods for which, if can be proven that one without the other would cause damage, then obviously one party should be penalized during the period. However, dominant cause or delay, that is the basic principle under civil law.
So your point is, sorry for interrupting, your point is that there is always a dominant cause. Yes. And you can never say that two causes interact in such a manner that it is impossible to make a differentiation.
It is. It never happens in reality. So concurrency needs to be taken with a pinch of salt. There is a need for a practical approach to it, but it needs to be taken into consideration always the dominant cause and the entitlement of the party that has been wronged and delayed in that respect. However, if can be proven that there are certain periods of time where both parties were in delay and both delays were critical, then obviously the party that will receive a compensation, some deductions will have to be done. And it's up to proper forensic delay analysts to identify those periods by using a balanced approach and a very practical and contractual approach.
And you said earlier that you consider that Romanian courts, I refer to dispute resolution cases before ordinary state courts, managed to, see through all this and provide appropriate, accurate decisions. Isn't it difficult, or is it, in my view, this is the most important disadvantage or shortage of this unfortunate decision to send to courts FIDIC contracts and FIDIC disputes? It is, according to Romanian civil procedure rules, impossible to administer this type of evidence in the typical way prescribed by the Romanian Civil Procedure Code. Isn't this, do you agree with me? Is it correct?
I do to a certain extent. My experience so far is that with matters of delay analysis, concurrency, the court have dealt pretty well. Despite the fact that the list of judicial experts, unfortunately, are disappointing in respect of certain specialties like a delay analysis. It's something
there
new.
Are no experts as
there
far
are
as I
no
know,
experts.
And they used specialists which are...
they are even less experts than them. But the judges have used common sense, and they have used the expert of parts that the parties have appointed in order to identify how credible their evidence was. And they have come up so far with very good decisions. However, local courts here do not have the sophistication of arbitration or the sophistication of technology or construction court like in England, that there are judges that are engineers and obviously they deal only with construction disputes.
It's a completely different perspective.
It's a completely different perspective.
Yeah. We don't have too much time left, and I would address a final question which I think is very interesting for all Romanian practitioners. You stay in Romania, you have your main base or headquarter here, but you work on all continents or many countries, 4 or 5 or 6 continents. What is, in your view, and this is a personal curiosity, and I'm sure the people watching us are going to share my view, what is the difference? What makes Romanian parties involved in dispute or disputes under Romanian law with Romanian parties different than in South America, North America? Is there a Romanian flavor, a Romanian something special to construction contracts and avoiding dispute and disputing construction contracts?
What I find in Romania is that there is an extremely sophisticated legal society and numbers of lawyers that have embraced the construction law, which you don't find in many other countries. There is quite a lot of construction lawyers, even if they don't, present themselves as such, but they are construction lawyers. And I am amazed day by day with my work that I'm blessed to find exceptional lawyers in this country, and generally the level of the legal minds here in this country is very high, because I think it was right place, right time after the fall of communism to embrace Europe, to embrace all the new ways of doing construction law, and they're doing a brilliant job.
I think this is a huge compliment for Romanian lawyers and not only for Romanian legal people, to say. And I'm also impressed by your assessment in relation to Romanian courts, which I agree. I mean, if you think of how many different files the judges are forced to deal with, the administrative court judges, and how well they manage to do it, this is really impressive from this perspective, looking at the judges dealing with construction disputes, public contracts, construction disputes.
Truly remarkable.
Yeah. Mr. Di Folco, it was a pleasure. Thanks a lot for your presence. Thanks a lot for sharing this amazing information and your perspective concerning Romania arbitration, and not only. I'm sure we are going to have some other opportunities in the future to have you back at the Arbitration Hour, and I'm sure that we are going to be able to provide a lot of valuable information for the more and more people that are interested in arbitration and construction arbitration, which is the queen and king of arbitration nowadays in Romania. Thanks again for your presence.
Thank you very much.
Încheiem ediția de astăzi. Sunt convins că a fost un subiect sau au fost subiecte excepționale pentru toată lumea. Ne revedem peste o lună. Rămâneți cu bine. La revedere!